Good day, students, and welcome to another narration in the chapter or the theme on servitudes. I would like to draw your attention to your prescribed book, specifically chapter 11, and it starts on page 256. In this narration, I will introduce you to the concept of personal servitudes. We will also cover the objects that can form the basis of such a personal servitude, and we will also discuss the rights that a personal servitude holder will have. So let's begin by defining a personal servitude first. A personal servitude can be defined as a limited real right to the movable or immovable property of someone else. Now that servitude grants the entitlements of use and enjoyment, the usufructuary, and the ability to draw fruits, the usufructuary, in respect of that thing to the servitude holder in his or her personal capacity. So a few important things to note. A servitude is a personal a personal servitude is a limited real right, and it forms part of our whole chapter on servitudes, again, all of which are limited real rights, and follows on very neatly from real security rights, which as a whole is also limited real rights. You should refer back to the chapter on things, where you discussed and reviewed the definition and the meaning of movable and immovable things. You should also refer to the chapter on ownership, where the ownership entitlements are discussed in full. Here, 2 of the 6 traditional ownership entitlements, the usufructuary and the usufructuary, are activated. And you would have seen from playing the role-playing game on the classification of servitudes that personal servitudes attach to a servitude holder in his or her personal capacity. In other words, as the holder of an identification number or as the holder of a company registration number. Now, over time, we've crystallized 3 basic personal servitudes. And I've listed them here in sort of an inverted triangle for you to convey the message that usufruct, which is at the top, use in the middle, and habitation at the bottom, all form part of sort of the same kind of personal servitude. However, usufruct is a more comprehensive kind of personal servitude. Use is smaller in scope, and habitation, while similar, is the smallest in scope. And these are called the so-called servitudes regulares. Now, we discussed the principle of numerus clausus a little bit earlier on in this course, and there we mentioned that South Africa did not receive the principle of the numerus clausus in any strict form into South African law. So the principle was left open for us to create new kinds or novel kinds of servitudes over time. Now, for prioritial servitudes, that can be created in many kinds of ways, and we've seen now that personal servitudes new kinds of personal servitudes can also be created, and they will not be called regular servitudes or servitudes regulares, but they will be called novel servitudes or servitudes irregulares. In this narration, I will focus on the rights of the usufructuary, the holder of usufruct, but I will leave it to you to see, read, and figure out how the general principles about the rights of usufructuaries differ or are similar to the rights of usuries, the holders of the personal servitude of use, and habitators, the holders of the personal servitude of habitation or habitatio. So please bear that in mind. What I'm about to discuss pertains strictly to usufruct, but needs relevant amendment and adaptation for purposes of use and habitation, and that will be for your own study. So a usufruct or usufructus can be defined as a limited real right in terms of which the owner or the grantor of a thing confers to the usufructuary a right to use the thing and to draw both the natural and the civil fruits from the thing to which the servitude relates. So you will see that there is a certain rhyme and rhythm to these definitions. In turn, and this is very important, the usufructuary must ensure that the thing is returned to the owner or the grantor without impairment of its essential qualities, or salvare substantia, upon the termination of the servitude. Now, I've recorded a separate narration for you on salvare substantia, which will not be covered in this presentation. Now, Professor C.G. van der Merwe explains that the social function of a usufruct is to confer on the usufructuary an income from the property for the duration of the personal servitude holder's lifetime, while someone else is owner of that thing. Now, a usufruct imposes a significant burden on the entitlements of the bare owner, because for all practical purposes, he or she will have almost no use and benefit of the property during the existence of the servitude. Usufructs can be created either inter vivos, that means between living persons, or mortis causa, that is in the context of succession in the terms of a last will or testament flowing from a person's death. And here you must please refer back to the notes that you made in your course on the law of succession. Part of the usufruct is that the servitude holder must acquire or gather the fruits within a reasonable period of time. If he or she fails to do so, the owner will have a residual right to swoop in and collect it for him or herself. Right, so let's have a look first at the objects that can form the basis of a usufruct. Now, here it is very important to appreciate that the object can be many things, and you must really discern the skill of reading attentively a set of facts and make notes for yourself based on your prior knowledge about the nature and the classification of things, and to see whether the application of the personal servitude fits with a usufruct. So first and foremost, a personal servitude of usufruct or usufructus can be established over any movable thing, any immovable thing, or a combination of both. It can also be established over a single thing or a composite thing, and it can be established over a principal thing, an accessory thing, or an auxiliary thing. Now, from case law and throughout many years of development, we've seen that this can crystallize into two concrete contexts. So in the rural context, this can typically include a farmhouse, the outbuildings, the cattle and the farming implements. And in the urban context, that can include the house or the home, the dwelling itself, the furniture inside, fixtures, the cutlery, and the crockery. In principle, a personal servitude of usufruct cannot be created over non-consumable things. And the purest or the plainest reason for that is because a personal servitude cannot be created over things that are destroyed through their normal use and enjoyment. So for example, you award a personal servitude over an apple or an orange, for example. If a person normally uses and enjoys an apple or an orange, they eat it, and through that eating process, that apple or orange is destroyed. Now that is problematic because you would have noticed from the definition of the personal servitude is that personal servitudes, or the object of these personal servitudes, must be returned substantially intact. And if you've consumed a consumable thing, that is essentially impossible to return. However, it is in principle possible to create a usufruct over a consumable thing. It's called a quasi-usufruct, much like in the law of possession when we talked about quasi possession. And here the obligation is changed slightly in that the thing that must be returned substantially intact is not the same thing, but it is a replacement value or a fungible version of that. So another apple or another orange would suffice. It is also possible to create a usufruct over a corporeal thing or an incorporeal thing. And from case law, we know that shares can form the basis of a usufruct. And here we must refer to Section 35 of the Companies Act of 2008, and specifically the judgment of Cooper versus Boyes nomino officio of the Cape High Court, as it was called then. And please also make a note here to refer forward to your lectures in company law when you do get there. I just wanted to create a visual pause for you. This is a photo that was taken just outside Stellenbosch on the way towards Franschhoek, over the sort of valley that goes out there, and here you have some vineyards and trees and beautiful mountains in the background. Okay, so let's turn to the rights that a usufructuary has. In the first instance, it's very important to remember that a usufructuary may resist any attempts from the owner of that thing to evict them in terms of the Prevention of Illegal Eviction from or Unlawful Occupation of Land Act, and that was confirmed in the Eastern Cape judgment of Sturdy versus Pirenzenthal, and the same applies to habitator, who can also resist in a similar position such an eviction, and that is the Supreme Court of Appeal judgment of Hendricks versus Hendricks. And interesting, we will shortly have a Supreme Court of Appeal judgment also about a different set of facts about whether the usufructuary can use this as a defense against an eviction application by the owner themselves as well. All right. The other rights that a usufructuary has is that they are entitled to the use and enjoyment of the thing, and to that extent it is applicable to the cultivation and acquisition of both natural fruits, or fructus naturalis, and civil fruits, or fructus civiles. And that's why I included the photos of the herd of sheep and the orchard of oranges over there for you. However, there's a very interesting point to note here is, what if the thing over which, or the object over which you create this personal servitude does not necessarily or by way of implication lend itself to the cultivation or acquisition of fruits? So here I want to think of for example, just a garden that doesn't have trees that produce fruits of some sort, or if you have a servitude over a painting or an art collection, or a servitude over a chair. I mean, a chair doesn't just by nature and over time produce other chairs. So the argument here is that where the nature of this thing is of such a kind that it doesn't naturally produce fruits, the better position would be, or the better approach theoretically would be, to not grant a usufruct over this thing, but rather to grant a use personal servitude over it. All right, so let's speak of the fruits. And here it is important to distinguish between civil fruits and natural fruits. So when in the case of natural fruits, the usufructuary will become the owner of those fruits when he or she collects it, and they will be responsible for all the costs that are associated with not only the cultivation but also the collection of the fruits. So here you can anticipate that the costs of spraying the orchard for bugs and with chemicals, watering it, maintaining it, paying farm laborers a decent wage for plucking the oranges or whatever fruit it is from the trees, will all be included in that cost of collection and cultivation. Now, the natural fruits that flow from a piece of arable land include vegetables and crops, while natural fruits that flow from cattle or livestock will include that animal's capacity to do work, produce milk. It can also include manure, wool, young animals, and the carcasses of those animals, all of which can also be the natural fruit of them. However, when the usufruct is established over a collection of things, like a flock of sheep, a herd of cattle, an orchard, as shown over here, or a vineyard, the usufructuary must ensure that the number of sheep, the cattle, the fruit trees, and the vines remain constant. It is in this context that Professor Andre van Walt explains that the use value that accrues to the usufructuary would then be to slaughter mature and injured animals and to fell infertile or dead plants rather than collecting them further, rather than collecting the further offspring, the fruits or the grapes, as natural fruit. Now, when the object of the usufruct is a stand of trees, Professor van der Merwe notes that the common law draws a distinction between silva caedua, or felling timber, and silva non caedua. And it is in this context that I would like to refer you to the textbook where I explain how this old common law definition needs to be updated with reference to our new constitutional dispensation, specifically the National Environmental Management and Biodiversity Act. All right, so with natural fruit, or fructus naturalis, completed, it is important to also appreciate that usufructuary has rights to collect civil fruits, and these civil fruits include rental income, interest on investments, and dividends on shares. But like natural fruit, the usufructuary would be responsible for all the costs that are associated with the collection of these civil fruits. Another important thing is that with the enactment of the Mineral and Petroleum Resources Development Act, this act abolished the private ownership of mineral rights. So it is simply impossible these days to establish a personal servitude, and in this case a usufruct in particular, over mineral deposits and metals. So you can't claim that as natural fruit. However, you can't claim them as a natural fruit, but if through the process of prospectation and extracting those metals and minerals from the ground through a licensee, the person can then get some civil fruits from that. The only exception in this regard is salt, because unlike other minerals and metals, salt regenerates by itself. So salt is perfectly fair play. You can harvest salt as a natural fruit, and you can then sell it to generate income for you, and that is then a civil fruit. So very important to remember, the only exception in this regard appears to be that salt, which is a regenerating mineral in its own, is not subject to this regulation. Right, from our classification of servitudes, you know that personal servitudes, and that includes all of them, usufruct, use and habitatio, cannot be transferred or bequeathed because it attaches intimately to a person. However, the right to draw certain fruits can be transferred. I want you to imagine here that you have a sick holder of a personal servitude, or a personal servitude holder that is advanced in age, and they cannot physically themselves draw the fruits anymore. So they could ask someone else to do that on their behalf, so get an agent of some sort, and through that there is a slight exception to the rule that the personal servitude cannot be transferred or bequeathed. However, it is still possible to obtain a pledge over a movable thing, and to register a mortgage over an immovable thing. Also very important is, and this comes from the classification of servitudes, is we know that personal servitudes inclusive of usufructs, use and habitation, are divisible. So this simply means that a co-owner can create a usufruct over a notional part of a thing, but that also one owner, a single owner, can create a usufruct over a notional part of a thing. And for that matter, the farm, a farm, which is an immovable thing, could have various personal servitudes over different parts of it. So it can be sort of split up into a picture puzzle, if you will.